Hey everybody, it's Chris Clark with discgolf.law. I'm coming to you today to let you know that Paul McBeth has been sued. Well, not Paul McBeth directly. The limited liability company that Paul McBeth co-owns with Chicago White Sox pitcher Dylan Cease. That company is called McCease LLC. That company has been sued in state court in Florida, and here are some of the details. Earlier this year, Mike Barnett, the owner of Sun King Discs and the tournament director for Throwdown the Mountain, told Paul McBeth that this would probably be the last year for Throwdown the Mountain at the Gran Canyon course. A private real estate developer had indicated an interest in acquiring the property for the purpose of building houses and creating a residential real estate development there. On March 23rd, Paul McBeth announced on Instagram that Paul and Major League Baseball pitcher Dylan Cease had worked out a deal to acquire the property and make the Gran Canyon course in Florida a permanent disc golf property. The intent, as he announced on his Instagram, was to rebrand and open in the fall of 2023. March 6th, about 17 days prior to that, appears to be the date that McCease LLC acquired this property, according to public records, for $1.2 million. Some of you may recall the story at the time. A lot of work was put in from local volunteers and interested parties to avoid having this classic disc golf property fall into the hands of a developer, which would have meant losing this property likely forever for the purposes of running disc golf tournaments on the property. On April 2nd, at the end of the Throwdown the Mountain tournament, McBeth won and gave a quick victory speech. And then there was an announcement made. A group of people, including McBeth, gave a short history of the Throwdown the Mountain property and the tournament. McBeth was given a ceremonial key to the course, and it was officially announced that McBeth and Cease had taken over ownership of the property. Now let's get you some details about this lawsuit. The plaintiff is named Trevor Tonez. I'm not sure I'm pronouncing his last name right, so I'm going to refer to him as the plaintiff or as Trevor. He's an individual, resident of Florida, and also either owns or is associated with a Florida disc golf pro shop called Local Route that claims to be the world's largest disc golf pro shop. Trevor has some history with this course. In 2018 and 2021, he won the MA50 division at Throwdown the Mountain. He entered to play and did in fact play the first 2 days of the 2023, I believe it was the week 3 or weekend 3 of Throwdown the Mountain. And so that would have been on March 17th. On that Friday, he had a good round. At the end of round 1, he was tied for 9th place. He came back the next day on Saturday, March 18th, and he shot the hot round in MA50, which was 3 under par. On Sunday, March 19th, the final day of the 3-day weekend tournament, Trevor, the plaintiff in this case, played the course, but he did not finish. He was on or near the tee of hole 12 and apparently was hit in the head with a drive coming from the tee of hole 11. For those of you who watched the pro coverage of Throwdown the Mountain, you may not be able to picture this because the holes are rearranged from when they do the amateur rounds over to when they do the pro rounds. So this is not the pro hole 11 and 12 that you might be used to seeing on YouTube or what have you. This was an amateur layout. The bottom line is this injury occurred apparently with someone throwing from the tee of hole 11 and hitting him on the tee area of hole 12. So shortly after, on March 24th, Trevor, the plaintiff, filed a lawsuit in state court in Florida against Gran Canyon Disc Golf Course. In his lawsuit, he alleges that the defendant negligently failed to use reasonable care and that he suffered significant injuries. For example, he claimed in particular that he suffered bodily injury, including a permanent injury to his body, pain and suffering of both physical and mental nature, disability, physical impairment, disfigurement, mental anguish, inconvenience, loss of capacity for the enjoyment of life, aggravation of an existing condition, the expense of hospitalization, the expense of medical and nursing care, loss of earnings, and loss of the ability to lead and enjoy a normal life. Thankfully, Trevor must be feeling better because according to his PDGA page, Trevor played 2 PDGA events in May, including the Clearwater Classic on May 6th and 7th, which he won in his division, less than 2 months after suffering the injuries that form the basis of his McCease lawsuit. In Trevor's lawsuit documents, he alleges that the defendants failed to maintain the premises, they created a hazard or an unreasonably dangerous condition, they failed to inspect the premises, failed to repair the premises, they failed to have adequate staff on duty, failed to train their staff, they failed to render aid when Trevor was injured, and they knew, or likely should have known, that injuries were likely to occur at this course. So why haven't we heard more about this type of thing happening? If you think of the sheer number of PDGA sanctioned events that take place every weekend, it's not a surprise that from time to time people must get injured. Well, there's a few possible reasons. One is all PDGA sanctioned events in the US and Canada, including Throwdown the Mountain, are insured under the PDGA Tour Insurance Policy. This policy covers PDGA staff, event volunteers, and registered players. Spectators and vendors are not covered by this particular policy. That PDGA insurance coverage includes medical costs for injuries sustained on tournament grounds during sanctioned play. So one possibility is that these types of injuries are typically handled directly through the PDGA under this insurance policy. Also, generally speaking, when a competitor enters a sporting event, such as a disc golf tournament, they often implicitly or explicitly assume a certain level of risk associated with participation. This is known as the assumption of risk doctrine. This is a doctrine in tort law which suggests that a person cannot sue for an injury that arises out of a risky activity in which they willingly participated and that they knew or should have known of the potential risks involved. So another reason that we may not hear about this type of thing as often is individuals understand that by playing disc golf in a disc golf tournament, there is the possibility that you may get hit with the disc. They accept this type of injury as the type of thing that customarily happens on disc golf courses and choose not to pursue legal action about it. A third possible reason is that frequently when participants enter a disc golf tournament, you must sign a waiver or a release form. A lot of times provisions about accepting the risk of injury are literally spelled out right there in these types of release forms. Probably all seen these. It's a form that competitors must sign before participating, and they usually detail the type of risks associated with the event, such as physical injury from competition, potential weather conditions, or accidents that might take place on the course. And they indicate that by signing, the participant acknowledges these risks and absolves the event organizers of liability for these types of risks. I have not yet reviewed the waiver that players signed at Throwdown the Mountain, but I have been assured by tournament staff for that event that all competitors are required to and did in fact sign a liability waiver and release for this event. But let me be clear, even with a waiver, an event organizer still may have some level of responsibility to take reasonable steps to minimize potential dangers, like ensuring that the course is properly maintained and is safe to use. If a participant is injured due to the negligence on the part of the event organizer, for instance, if there were a dangerous condition on the course, the organizer knew about it or should have known about it and failed to correct the problem or warn others about it, then the participant might still be able to bring a legal claim, even despite having assumed the risks involved. As a result of this lawsuit, the Independence Day Clash X, or 10 maybe, is being relocated to another course. Sun King posted online that in their opinion, the lawsuit was filed purposely to keep Gran Canyon from becoming a permanent course, and that depending on how long it takes to resolve this dispute, Throw Down the Mountain 2024 is potentially in jeopardy. So I'm curious to hear your thoughts about this type of event. This is, as I mentioned, certainly something that happens from time to time when we play disc golf. Is the plaintiff right here in seeking damages for his injury, or should the course owners and tour directors and event staff not have to face lawsuits from these types of events? Let me know what you think in the comments, and as always, don't forget, like and subscribe. Thanks for watching.